ways of ring fencing the assets in case of unhap that happens, how your spouse will benefit of the asset during her lifetime, and eventually look at passing on the wealth to the next generation. So we just don't go skipping steps, but yet ultimate objective is to pass on the wealth, but how it goes in the most sophisticated and smoothest way is how it works. So the laws in India are very simple. There is no state laws, country laws. The laws that govern your succession is the religion that you are following. So if you are a Hindu family, assets will be equally distributed amongst all legal heirs. And this is when you don't have a succession plan in place, when you die intestate, which means without doing up a will or without having any succession plans in place. The assets will be distributed as per the religion that you're governed by. So in a Hindu family, assets will be equally distributed among all legal heirs, whereas in a Muslim family, it will be as per the Sharia law. In a Christian and a Parsi, again, it is the Indian Succession Act that governs the rule, which again says equal to all legal heirs. When we say equal to all legal heirs, it can become very complicated. When you have one house that you're leaving behind, what do you mean by equal? You have two sons, you expect both the sons to start living in that one house. You expect one to pay rent to the other. You expect that the house to be sold and then the proceeds to be transferred to both of them. So equal is very unclear. So it is always better to start and plan a way forward so that you have clarity and you can avoid unnecessary disputes that can arise between the family because of you not planning it well. The same way, there are a lot of myths and understandings that we carry in our mind, which is very different from reality. Um, most of us here, or at least the clients that I have met, most of the time they have an intention that after me it goes to my spouse, after my spouse it goes to me. In absence of both of us, it will go to the trust or it will go to the next legal heirs. But those intentions are really not met because if you don't plan for it. So when you say that after me, everything should go to my spouse, and after my spouse, everything should come to me. In absence of both of us, it should go to our children. But if you don't document this in some form or the other, and the most easiest one is the will, then natural succession laws will trigger it, which means after you, your wealth will go to your spouse and your children in equal proportion. Or after your spouse, her wealth will go to, or his wealth will go to the surviving spouse and the children in equal proportion. But the intention in your mind is that it should go to the spouse first. After the spouse, it should then come to me and then to the children. So that intention gets defeated if you don't plan for it. Similarly, there are other ways that people have tried and do things by saying that I have everything joint with my wife. So if I have everything joint with my spouse, do I really need to do up a will? Because everything is joint. So a joint applicant, for example, taking different asset classes, a real estate. Okay, if it is joint with your spouse, your share on your demise does not by default go to your surviving spouse. It goes by default to the surviving spouse and the children as natural succession. So by saying that I have properties joined with my wife, you will have not taken care of your succession needs. The surviving heir does not become the rightful owner of the 100% property. The deceased's property will get distributed to the surviving spouse and the legal heirs in equal proportion. And that is very different from what your intentions were. So joint applicant is not a solution, but that is one of the notions that we carry, that because I have everything joint, it is taken care. Similarly, you have bank accounts. You say that everything is joined between me and my wife, which means that on absence of one or the other, we don't need to really plan for it. Again, that is not reality because a joint applicant in a bank account is only for ease of management. It is not for succession. So if you really look at it from a legal standpoint of view, the account is to be frozen on demise of one of the beneficiaries, and the proceeds then go to all legal heirs. It does not become either a survivor. Either a survivor status is only for ease of management of the account, not for succession. So these are small myths that people have in mind, and they think that they have planned the succession, but then this leads to more complications later. Similarly, nominees. A lot of times what happens is that you say that I've done nominees in my account. A nominee, again, is not a legal heir. A nominee is only a guardian. The role of the nominee is to collate all the assets of the deceased and distribute it equally to all legal heirs if there is no will or if there is no succession plan in place. So the nominee is not the whole and sole owner of the properties or the assets that are left behind. He is only a guardian. And that is where, again, problems start, because in our mind, we've done investments also in such a way that this investment will go to this nominee, the other investment will go to the other nominee. But that's what you think in your mind it should happen. But if you go legally, the nominee's role is very different. His role is to collate all the assets and equally distribute it to all legal heirs if there is no will. So if you're looking at easing out life for yourself during a lifetime, which I will cover in the later half of the talk, but if you're looking at easing out your life for your siblings or your loved ones who are going to inherit the wealth after you, then there are better ways to plan it than, say, joint applicant and nominee. Nominee and joint applicants are not ways of planning your succession. So there are two broad tools for succession. One is writing up a will. A will is a static document that comes in play on the demise of an individual. It carries your wishes of how you would like to distribute your assets to the next generation. You can do as many number of wills as you like. The last will is considered as your final will. A will written by hand, a will on a computerized printout is as good as each other. So there is no better will that's saying that a handwritten will is not accepted or a computerized will is the only way it should be. Do I need to do my will on a stamp paper? Do I need to register my will? So yes, you should be doing your will correctly. And the correct way is by doing a will in the first place. Whether it is handwritten or computerized does not matter. That is immaterial. Um, Registration of a will is not mandatory, but it is always advisable that you register your will, because a registered document holds more weightage than a unregistered document. But at the same time, a handwritten will or a computerized will is as good as each other. There are other small things that you should take into consideration while doing your will. Your will should be very precise and to the point. You can't make your will complicated where it leads to a stage where it can be interpreted by somebody else in a different way. Because if and a done, the can change the meaning, and you may not be there at that point of time to explain what you meant. So your will should be very simple, very precise, and to the point. In the past, I have seen wills which run into 50 pages, 30 pages, where families have written letters to each other or parents have written letters to children. That's not the way it should be done. Your will should be specific to the point, carrying your assets. You can do as many number of wills, but your last will be considered as your final will. So assuming that in 2000 you've done one will, and 2012 you decide to do another will, and 2020 you do another will, the 2020 will be considered as your final will. If you have registered your previous wills, you should go and deregister those wills or re-register this new will on the old will. At any point of time, there should not be multiple wills floating around. There should be only one original will that should be there. The parties to a will. So you have the testator, the one who's actually writing the will, or whose will has been written. Then you have the set of beneficiaries who will benefit out of it. And you have set an executor. The executor's role is to actually execute the will. So there are certain states like princely states, they call it, which is Bombay and Calcutta, where a probate is mandatory to execute a will. In other states, probate is not mandatory. So if you are living in Bombay and you have assets in Delhi, you can execute that part of your assets without probating your will. But for your Bombay assets, you will need a probate. Similarly, if you are living in Delhi and assets in Bombay, your Bombay assets will require a probate, your Delhi assets will not require. A probate is nothing but going to the court and applying for a grant of execution, and the court will then check into the authenticity of the will check that everything is correct, there is no misinterpretation or tampering of the will that has happened. And it will then write into 3 different newspapers that this will is getting executed. If someone wants to contest, please come now. It will invite people to contest. If nothing happens in the next 6 months, 9 months, is then the court will give you a grant to execute the will. The executor's role again becomes very crucial. because he's the one who's going to be doing all this running around. He's the one who's going to be actually in charge of distributing your assets to the beneficiaries. So appointing a right executor is important. Um, you can, most of the times we've seen that we appoint friends or family as executors who are 3 years or 4 years elder to us or 3 years, 4 years younger to us. In most cases, this becomes difficult because if you hit the bucket at 80, your executor would probably be 78 or 82, and you expect him to run around for you at that point of time, asking for a little too much. So appointing a right executor becomes very important. Either you appoint somebody from the family who is younger, or you could appoint a corporate executor. Similarly, can a beneficiary also be an executor? Yes, a beneficiary can
Tariq,
also be an
can you
executor.
just move your slide, please? I think you've not moved
Yeah,
it.
a beneficiary can also be an executor, but at the same time, it is better that the beneficiary uh, is in India, because again, for an NRI to leave his stuff and start living in India for a longer period of time to get things done becomes a little tricky. If you have multiple beneficiaries, can one of them be the executor? The answer to that is yes. Should one of them be the executor? Maybe, maybe not. Because again, if that beneficiary is not getting enough from the will, and without executing the will, he's exercising rights over all the assets because he's living in India, he may keep deferring the exercise of executing the will. And that can again lead to more further complications. So identifying the right people to do the right job becomes very important. Similarly, we've come across common questions like, can I do a joint will? Most of my assets are joint with my wife. Can I just do a joint will? Uh, Again, a joint will not really be helpful because um, once a will is executed, executing an executed will gets even more tricky. So it is always better to have an independent will for you and your spouse. Similarly, at the same time, if you are willing all the assets to your spouse, her net worth and her assets list may change. So she has to anyway redo a will. So it is better to have an independent will from day zero. There are other points that we come across is that, can I will it to my wife, and after my wife I wanted to give it to my son? So you cannot do multiple layering in one will. So you can will it to your wife, but after your wife, you cannot decide who it goes to. It will go as per her will. So if your wish is that it should go to my wife and after my wife it should go to my children, then you have to look at other tools of succession, which could probably be a trust. A trust is a living body that runs parallelly with you. It carries the wishes of how you would like to distribute your assets during your lifetime. You can be a beneficiary of your own trust, benefit out of it, and then look at passing it on to the next generation the way you desire. The fundamental difference between a trust and a will comes into play on the demise of an individual. It carries the wishes of how it will be distributed. It needs to be probated in certain states. It can be contested by anybody. If it is contested, it will run into multiple number of years. A trust is a living body that runs parallelly with you. You can be a beneficiary of your own trust. So your old age, retirement, all of that can be taken care by the trust itself, by the set of trustees who will manage it for you. And the balance wealth which is left over can get passed on to your legal heirs in a more sophisticated manner immediately after your demise. Need not require a probate, need not require transition. All of that can be done much easily through a trust. A lot of families today prefer using a trust over a will, but in most cases, it's a combination of a trust and a will, because not necessary that you will move 100% of your wealth into the trust from day zero. So you will always have certain wealth which is outside the trust for which you will require a will. The majority of the wealth can be moved into the trust, which will be for the benefit of the beneficiaries eventually. Internationally, there is something called as inheritance taxes, especially in the US and UK, or estate duties as they call it, which means wealth passing from one generation to another is subject for taxes and to the tune of 30 to 40%. Currently in India, we do not have inheritance tax and estate duties, but there has always been a hue and cry during the budget that estate duties will get introduced in India, could get introduced in India. Will it happen? Will it not happen? We don't know at this moment. But if it happens, then a trust is the only solution that will help you to protect that inheritance tax. A will not be a solution for that. In a will, assets change hands. In a trust, assets don't change hands, the underlying beneficiaries keep changing. Since the assets are not changing hands, there is no demise, and due to which inheritance tax or estate duties will not be applicable. At the same time, certain families prefer to do up a trust when there are minor children involved. So if I have minor children, on my demise, what will happen? My child cannot inherit those assets because he's a minor. Then uncle, auntie, chacha, chachi, everybody tries to contribute. It becomes a mess. So I'd rather do up a trust and have a plan for him in advance. Similarly, you could have dependent parents, old age, their medical expense, their day-to-day expense. You would prefer to do up a trust than do a will. At the same time, uh, in certain cases where a lot of business houses, a lot of directors in companies where the liability is very high as a director. As a promoter, you are running businesses, you are leveraged. You've taken personal guarantees, you've taken leverage from multiple places. The way things are moving today, anything can happen. God forbid if something goes wrong and your business gets into difficult times. Your personal guarantees can get revoked, and all the wealth that you have accumulated over a period of time can get attached. But if you do up your trust in the right way, and you can ring fence those assets from any market liability that may arise. Similarly, in a marital dispute. So a lot of business houses prefer that when they are moving away their personal wealth into the trust, they're ring fencing it from any market litigation that may arise in the future or that could arise in the future. But at the same time, a lot of families also prefer to ring fence the assets from a marital dispute. So if I have a daughter, during her wedding, I've given her X amount of things, it's now hers. If something happens to her, if she has children at that point of time, her wealth will get distributed to her children and to her husband. But if something happens to her before she's even got a child, then the entire wealth goes to her spouse. Nothing comes back to you. So you can control those kind of things also. In case of a marital dispute, the spouse can claim 50% of the wealth, which is in my name. But the wealth which is in my trust is protected from a marital dispute. I mean, our generation coming after us, divorce and separations are becoming more and more prominent, more and more common. So how do I protect the interest of my child? How do I protect the interest of my family? All of that becomes very important for the wealth that we are leaving behind for them. Similarly, in case of a special child, a lot of families that I've come across have the biggest concern is what about my child after me? While I'm there, I'm doing everything, but what about me not being there? Or if I'm unable to contract, who will take care of my son? Who will take care of my daughter? Who will take care of their needs? They are not sufficient to manage their own. Again, a trust is an answer because the trust will help you to take care of things during your lifetime, take care of your loved ones after you, and continue the relationships going forward. Any individual, what you own in an individual capacity can be held by the trust. There are two broad categories of a trust. One is a revocable trust and the other the irrevocable trust. A revocable trust is a two-way traffic. Assets can be moved into the trust, can be taken back by the settlor at any point of time. The settlor is the one who will actually settle his interest into the trust. For the benefit of the beneficiaries can be family members, the beneficiaries can be uh, parents, children, anybody, anyone who's in the bloodline relative definition of income tax can be the beneficiaries to avoid any unnecessary gift tax. So a revocable trust, the settler can take back the wealth at any point of time. The settler can also be a beneficiary of his trust. So if I'm not looking at asset protection, or if I'm not looking at any market litigations coming my way, but I'm only looking at succession planning, a revocable trust can be a very good option for me to plan my succession through the trust. I can be a beneficiary of my own trust, get full benefited out of it. My old age and retirement, medical expense, day-to-day expense, everything can be taken by the trust. My spouse can be a beneficiary along with me in case I hit the bucket before her. Then the trust continues to take care of her needs. In absence of both of us, the children can become the successor beneficiaries. So you have a primary beneficiary and you have a successor beneficiary. So that becomes very important how you design the structure. Similarly, if you're looking at asset protection and you're looking at ring fencing of assets from any unforeseen events, then a revocable trust will not be helpful because a revocable trust is considered as the assets of the settler, tax in the hand of the settler. But an irrevocable trust is considered as an arm's length distance where you settle your assets into the trust. You do not benefit out of it. Since you are not benefiting out of it, you have relinquished your ownership into the trust. It is not considered as yours. What is not considered as yours cannot be attached. In an irrevocable trust, there are two subcategories. So you have a discretionary trust and you have a determinate trust. A discretionary trust is where the shares of the beneficiary are not defined. So I have moved assets into the trust, but at this point of time, I do not want to do the distribution in terms of demarcating percentage of who's going to own how much. I will decide that over a period of time. So you have the flexibility of doing that by keeping the trust discretionary in nature, where the
Tariq, can you
percentage of the
please, sorry to interrupt you, can you please move the slides?
so where the beneficiaries of the trust are not defined, and uh, you can always come back by saying that over a period of time, I will define the beneficiaries of a percentage of my trust. The beneficiaries are defined. In that case, the assets of the trust are considered uh, of the trust itself and tax in the hand of the trust. Then you have an irrevocable determinate trust where you can define from day zero that the assets will go in this particular manner, in this particular percentage for the benefit of 1, 2, 3 ABC beneficiaries. In that case, the taxes are in the hand of the beneficiary. So revocable trust, very good tool for succession. Assets of the trust considered as assets of the settler. Settler can be the beneficiary of his own trust. A very good alternative for a will. Now, irrevocable trust, where the settler cannot be the beneficiary of his own trust or should not be the beneficiary of his own trust. You have a discretionary trust and you have a determinate trust. So depending on your wishes, depending on your needs, depending on your requirements, accordingly, the trust can be designed and the taxes will vary the way the structure is. So if I have children living in the US and UK, where inheritance tax is already introduced, if I, on my demise, I will infuse their net worth by an X percentage. On their demise, they will be subject to the 30 or 40% inheritance taxes depending on the net worth and the state they live in. That can be avoided by just doing up a trust and willing or gifting assets to them through a trust instead of giving it directly to them. So there are multiple ways you could plan your succession. There are multiple ways you could design how you own your assets and how you manage it during your lifetime. And these are more customized solutions which vary from family to family, which vary from individual to individual, and accordingly, so there is no copy paste, cut copy, similar structures that are used for everybody. Every family is unique and every family has unique requirements, and we'll be happy to uh, assist you in whatever way we can.
Thanks, Tariq. That was quite informative. In the meantime, if you have any questions for Tariq, please do write on the Q&A section and I will read it out to Tariq. Uh, Tariq, first I have a question. Uh, what is the strategy to create a robust plan? And what stage in life it should be created? And is there any model for allocation of wealth? And how do we get the successors involved in this entire plan?
Okay, so what I understand from your question in a robust plan, uh, I would like to believe that you have multiple assets in multiple geographies with multiple asset classes. So there is no one answer to that. Just to try and answer that a little more simpler, what is the right age to plan my succession? I think we are already late because the moment I buy my first asset, I should be keen to know how it will go to my beneficiaries eventually. So the right age to plan your succession is the earlier you do, the better it is because we don't know how long our lifespans are. So there is no right age. The earlier we do, the better it is. Similarly, uh, how I should plan obviously varies in terms of what your wishes are. If your wishes are to ring fence the assets for your children over a period of time, then a trust is a better structure. If your wishes are that you should be able to utilize your assets during your lifetime, then probably a revocable trust is a better structure. If your wishes are that I just want to give away and after that it's their life, they can do what they want with it. I don't want to bother about how they're managing and what they're doing. You could just do up a simple will. Uh, there are a lot of times when there's cross holding between families. There are a lot of times when there is uncertainty in terms of ownership and control in when it comes to business family specifically. So I am into business. I am managing everything for the family. My school children's education fees is going through the company. The cars name in the company. Everybody has everything, but literally when I look at the structure, nobody owns anything. So that's where again complications start. That ownership and management and control. Who's going to inherit the profits? Who's going to inherit the company? Who's going to manage the company after me? So all of this needs to be well thought, well designed, and accordingly planned.
I think there's one client who's raised his hand, Mohan, so I'll just unmute him to ask.
Yeah.
Mr. Sham, you have a question? Mr. Sham, you can speak.
Yeah, I'm just still framing my question. Give me a moment, I'll ask. Okay, just
All right, all right.
So, Tariq, in the meantime, we have questions in the question and answer box. The first question is, can a property be bequeathed with conditions, say it cannot be sold for a certain number of years?
Yes. If you are willing that property, then putting in conditions are limited. You can only put in uh, conditions to the extent of living interest. So, say for example, my mother is still alive, and I want to will the property to my wife, but I do not want to give the rights to my wife or to my children to sell that property till my mother is alive. So I can always will the property to my wife or to my children with the condition that the living interest goes to my mother. So at any point of time, she will have the full rights over that house to stay in till she is there. And that house cannot be sold till she doesn't decide to sell it or gives permission because she has living interest in that. On her demise, then of course it is now belonging to the person who's inherited it through a will, and that can be done. So you need not have to be gifting it to your mom first and then giving it to your wife again. You can give it to your wife directly with a living interest to your mother. That's one way to do it. The other way is you hold the property in a trust and you decide everything in that the income from there will go to beneficiary one. If the property is sold, it will go to beneficiary two, or however you want to do it. Or this property can never be sold, or this money that comes can only be used for XYZ reason. All of those combinations you can do in a trust, but in a will you can only bequeath living interest. Said that, there's one thing that we should keep in mind, that when I am moving assets from an individual to a trust, the assets that are moving will attract stamp duty only in real estate. So if I have cash in bank, if I have mutual funds, if I have investment portfolios, I have company shares, all of that can move to the trust without any stamp duty implications, without any long-term, short-term, zero taxes. But if I have real estate which is in my individual name and I move that to the trust, I need to pay stamp duty again because I'm re-registering the property in the name of a separate entity now. But if you have real estate which is held through a company shares can be moved to the trust, no stamp duty applicable. So that is how assets can be moved to the trust. At the same time, if you will the assets to the trust, which means if you will the real estate to the trust, it will not attract stamp duty. And that's where a combination of a will and a trust comes in play, where most of your liquid assets and investment portfolios and company shares, cash in bank, all can be moved to the trust today. For the real estate, we could do up a will, and those real estate could move to the trust after, through a will.
Thanks, Tariq. Uh, we have a question from Ms. Renuka Chauhan. Ma'am, you can ask your question directly to Tariq. I have unmuted you.
Thank you. A very nice session. I just wanted to ask who manages the trust, and meaning who decides who will manage the trust, and are there any charges for the managing the trust, or um, like and what does management actually mean of a trust?
Okay, so one is that there are three parties to a trust. One is the settlor, who's settling the interest into the trust for the benefit of the beneficiaries. But then there has to be someone who will be managing that particular assets or that particular trust for you. That particular person is called the trustee. So you could have a family member as a trustee who will then execute all the instructions from the settlor for the benefit of the beneficiaries. If it's a family member as a trustee, then there is no annual management fees or cost involved. But in most cases, people prefer to have a corporate trustee. If you have a corporate trustee and he's rendering services to you, he will come with a fee, and the end-to-end management can be done by the corporate trustee, distribution of wealth, uh, for the investment that the trust does, so execution of those, redemption that the trust will do, execution of those, medical expenses for the family, day-to-day expenses of the family, everything that you would do in an individual capacity, the trustee will do for you. But the decisions will still be taken by you. So you have appointed a manager to the trust or a manager to your company. In the same way, the decisions are taken by you. They are only executing what you have decided.
Thank you.
Thanks, Tariq. We have another question. The question goes like this. For NRE funds, like with banks or investment in securities, settled into a trust in India, do they get converted to NRO?
Yes, if you are moving NRO money into, see, a trust is a domestic trust and can hold Indian money. So if you are moving NRE money into a trust, it will not be considered as NRE anymore. It will become domestic money, and all domestic taxes will apply.
So, a following question on that, Tariq, is how useful a trust in India would be for NRI living abroad with assets in India?
So with assets in India means what? Assets in India are Indian assets. So an NRI can always move his Indian assets into the trust, not necessary that he needs to move his NRE money into the trust, because the NRE money is repatriable and you can repatriate 100% of the money. But domestic money has a cap of how much you can repatriate. In case of an NRI, you can repatriate up to $1 million. So in most cases, NRIs have domestic money and foreign money. So the trust will be helpful for the domestic money that they have. For the NRE money, they can set up an offshore trust depending on where they are resident of. So we can help them with domestic trust, we can help them with cross-border trust, international trust also.
Okay. Next question is, do we need a probate if our property is outside Mumbai or Calcutta? What is the right way to plan succession for reality? How will the title change? Do we need to do a stamp duty, etc.?
Okay, so probate is mandatory only in Princely States, Bombay and Calcutta. So in the first case, if I am having property in Delhi and I die intestate, which means without a will, then my family members will have to get a succession certificate from the court proving that they are the only legal heirs and there is nobody else besides them. So in that point of time, a succession certificate is required. But if I have a will, then I can transfer the assets to the beneficiaries without going to the court and getting a succession certificate or a probate outside Bombay and Calcutta. Similarly, will there be any stamp duty? No, there is no stamp duty if you are inheriting assets. There is no stamp duty even if you're gifting assets during the lifetime. In certain states, of course, that varies from state to state, but for inheriting of assets through a will, there is no stamp duty in any state.
Okay, and if the company is holding that real estate, then what happens?
Same way, there will be no stamp duty or long-term gains or capital gains or anything, because those will arrive only when if it's a sale against consideration. Over here, there is no sale, there is no consideration. It is pure succession. If it's a company holding real estate, you can even gift it that shares to the trust without any stamp duty. Stamp duty will only apply if you are moving assets into a trust during your lifetime. If you're willing it, stamp duty will not apply.
Yes. On similar line of real estate, next question is: can a property be willed to a person subject to the person inheriting it only on attaining a certain age?
No, you cannot do a conditional will again, because what if you are willing a property to your son and saying that he should inherit this only when he's 22 and you pass away when he's 15? So for that period of 10 years from 15 to 22, who is going to own that property? So it will basically go to your son and he will be managed by guardians, that also only till the age of 18 and not 22. Because guardianship laws also finish once the third term measure, which is 18. So in cases like those is where the trust comes handy. You can will it to the trust and you can say that the benefits will go to my son during his lifetime, and he can sell the property at the age of 22 or 25 or 30, whatever you want. But in those cases, the will not work. A trust will be a better tool to use.
Next question is: do trusts set up in India have validity outside India, say in US, Europe?
Yes, for your Indian assets, you need to take consideration of the domicile of the beneficiary. So if your beneficiary is in the UK, then while doing up your trust in India, you need to take UK laws into consideration. If your beneficiary is in the US, while designing a trust in India, you need to take into consideration US laws. So depending on where the ultimate beneficiary would be, those laws also need to be taken into consideration.
So next question is: there are a lot of online portals which are facilitating writing a will. What are the pros and cons of those portals?
In my view, writing a will is not a big thing. How to write it is important. What should be written in the will? How should the content be? So if you want to do an online will, I would suggest that you just go down to Google and put in free will. You will get umpteen number of wills. You can read it and pick up any of the free wills that you like, and do it from there. Because the online will do exactly what you feed in. They're going to give you an input of that. But what you're feeding in is correct or not? Should it be fed that way? Should the assets go to your son or to your daughter? The consultancy part, the personalization and the advisory part is what is more important. So before you know how to drive, that's the piece which is very important, then start driving straight. So similarly, the amount of time that you would spend around in understanding what you should do, how you should do, what are the tax implications around it. If I do this, then what? If I do that, then what? All of that portion gets missed out in the online portion. So instead of doing up and just putting data entry on an online and getting a piece of paper back, you rather take it free from Google.
Thanks. Like the next question is: if an asset is moved into a trust, can it be moved back?
So if it's a revocable trust, the settler can revoke his rights and take the asset back in his capacity. If it's an irrevocable trust, then it can go only downstream for the benefit of the beneficiaries. The settler cannot take back assets from an irrevocable trust. He can definitely take back assets from a revocable trust. So the irrevocable trust is a two-way traffic. Assets can be moved in, moved out, considered as assets of the settler, tax in the hand of the settler. Irrevocable trust is a one-way traffic. Assets can only go downstream, cannot be taken back by the settler.
Thanks, Tariq.
If you're not really looking for asset protection, you could start planning a succession through a revocable trust and start moving assets into the trust gradually, because there is no rule that you have to move everything you own today into the trust. You can move some assets, get familiarized with it, move more assets, get more familiarized with it. Over a period of time, you could plan your succession slowly and steadily.
Thanks, Tariq. Tariq, any broad idea of the fee structure?
So it will all depend on the complexity and scope of work. But as you know that there is a preferred pricing for InCred clients. So those benefits will get passed on to all clients coming through InCred. But There is no MRP to it. It will all depend on the complexity and scope of work. But in my view, pricing is not a showstopper. They're all customized pricing and preferred pricing for all clients.
Thanks, Tariq. Next question is, do you have to pay stamp duty if you move real estate into revocable trust?
Yes. In both cases, since you are changing the ownership and re-registering the property, you will have to pay stamp duty.
Thanks, Tariq. Let me just check whether.
There's a hand raised, Mohan.
Yeah. There's a question asking for suggestion of the agency which can help in the formation of trust. Yes, Amicorp can help you in the formation of trust. You can talk to your InCred RM. He will set up a meeting with Amicorp and get your trust formed accordingly.
Yes, we could help you with the entire end-to-end planning, starting from understanding the requirements to getting into consultancy advisory to implementation and also acting as a trustee on an ongoing basis. Like InCred helps you with your entire wealth planning in terms of how to invest, how to do all your investment needs. We will help you with all your family needs. And that's how we work as a team. We at Amicorp do not do wealth advisory, because your trustee and your wealth advisor should never be the same person. There's always a conflict of interest, and you should always have an independent trustee and an independent wealth advisor, because there's a huge level of conflict of interest that can arise if the wealth advisor and the trustee are the same, and is why we work with likes of InCred, and they don't work with having their own in-house trustees. It requires a dedicated expertise and dedicated scheme of work to be done.
Thanks, Tariq. Next question is, what a Hindu should particularly do to think about will or trust?
Sorry, come again.
What should a Hindu do? He should do a will or do a trust?
It doesn't matter whether you're a Hindu or a Parsi. What is your wish? That you want to bequeath your assets to your children in a particular manner. You want to benefit out of it during a lifetime and then give away. How you want to use it, and all this that we discussed in the last 1 hour depends on what your wishes are, and accordingly, a solution can be provided of which tool to use to fulfill your wishes. So Hindu or Parsi doesn't matter.
Thanks, Tariq. Next question is from Ms. Renuka Chauhan. I have unmuted you, ma'am. You can ask your question directly.
We can't hear
Sorry.
you. Hello.
Yeah.
No,
we can hear you.
I did not put in a request. I raised my question earlier, so that's done.
Okay.
If you can tell more about the fee structure for an HNI for a normal assets like their bank accounts and one house.
Mohan, I think fees is a little tricky because we'll have to understand the scope of work and then get to a number. We could always have a one-on-one call with Renuka ma'am. Get more details from her and then put a fee.
Sure, Tariq.
Okay, thanks.
Yes, ma'am.
Mohan,
So
we can't hear you.
next question is from Mr. Ajit Singh. I'm just unmuting him. Yep. Good, sir.
My question is, can a husband and wife together be the settlers of a revocable trust?
Yes, the husband and wife can be the settler and the beneficiary of a revocable trust. So you can have multiple settlers and multiple beneficiaries
Thank you very
of
much.
the same trust.
Oh, thank you.
Mohan, do we have more questions?
Yeah. The question
You want me to read them out?
complete. Yeah. Sorry, it's asking about what about HUF?
So an HUF is again old school of thought. In an HUF, what happens is that you don't decide who the beneficiaries or the co-partners as an HUF are. When a child is born in the family, he by default becomes a part of an HUF, whether you like it or you don't. In an HUF, again, you don't decide the percentages of distribution. You might have two sons. One is doing very well. The other is still setting up his structure or career. You might want to help him with more wealth. In an HUF, everything is equally distributed. You can't choose who the beneficiaries will be. You can't choose how much beneficial interest it will be there. The karta of the HUF again is by naturally the next legacy senior member of the family becomes a karta. Now even the lady can become a karta. A lot of things are by default there. So you are molding yourself with the HUF. You are molding your needs to match in an HUF. Whereas in a trust, everything is customized. It is like water. You give a size and shape to it. So instead of you changing your wishes to meet the wish of the rules of the HUF, you make up a trust and you let the trust, you decide how the trust will run, who will inherit how much at what point of time. In a HUF, again, the karta takes the shots. In a trust, you can have different people managing different roles. You can have particular assets. So HUF is a pool where everybody is benefiting from everything in the HUF. In a trust, you can have demarcations of this much wealth will go to this person or income from this property will go to this person. All of that can be customized on a personalized level, unlike in a HUF. So HUF is a more older way of doing things, whereas the trust is a more refined and a precise way of doing things. Similarly, internationally in US and other countries, they don't even recognize HUF. So again, it becomes very tricky for families with beneficiaries overseas to do up in an HUF. Similarly, in an HUF, again, if the karta gets into any litigation, the assets of the HUF can get attached. Whereas in a trust, once the settler is settled the assets, whatever happens to his level of interest, the trust assets cannot be attached. Obviously, if it's done the right way and keeping certain things in mind. So there's a very big difference between the two. Really should not be compared.
Thanks, Tariq. I am unmuting Mr. Shyam Suri. He has a question to ask.
My question is specifically if a person doesn't have any corporate liability, most of his wealth is of personal variety, then do we need to seriously consider ring fencing and irrevocable trust?
No, sir. If you do not have any liability, you do not foresee any liability coming your way, you need not even go to a irrevocable trust. A revocable trust is more than sufficient because what we are really doing is we are planning for your succession, that's all. And that can be done through a revocable trust. You need not worry about you don't need a irrevocable trust at all.
Got it. Thank you so much. Thank you.
Yes, sir.
Thanks, Tariq. We have a question from Mr. Alok Mimani. I'm just unmuting you, sir. Please go ahead with your question.
Yeah, quick one. So thanks so much, Tariq. I think what we understood is that the revocable trust is probably the best option, except that when you're transferring property or real estate to a trust, it should be done through a will to avoid the stamp duty. My one simple question is, can the settler of a trust can also be the managing trustee of the trust?
The settler can also be a trustee of the trust, as long as you're not looking at asset protection and irrevocability, and because to derive asset protection, you need to relinquish ownership and control. By moving the assets into the trust, you've relinquished ownership. But by being the settler of the trustee of your own trust, you have still not relinquished control. So it is not exactly giving you asset protection. But what you could do is you could be the protector of the trust who overrules the trustee, and the trustee seeks guidance from the protector. So if you're looking at succession planning and you're doing up a revocable trust, it's absolutely okay for you to be the managing trustee as well.
Okay.
No problem at all. But if you're looking at asset protection and doing an irrevocable trust, preferably you're not the trustee.
Can you explain asset protection, please?
Say, for example, you are into business. To expand your business, you've taken bank lines.
Okay.
You have creditors or debtors that have to pay you, or receivables, and a lot of liabilities that can come your way.
Okay.
And if something goes wrong and things don't go as planned, then your personal assets can also be attached. Due to which people prefer to ring fence the assets in a trust, the ones that they have already earned over a period of time, so that the new expansions or the new liabilities cannot impact your existing assets.
Okay.
And that's where you do up a irrevocable trust. But like sorry, sir.
Just one last question on the trust. So since trust is a separate legal entity, obviously you need to get a new PAN card and all those things. So basically the income which the trust is going to earn out of all the assets transferred to that will be liable to taxation, right?
Yes, and the taxes will vary on the way the trust is designed.
Okay.
So if it is a revocable trust, though it has its own identity and own PAN card, the income of the trust is considered as income of the settler, tax in the hands of the settler.
Okay.
If it is an irrevocable trust, it is discretionary, which means the shares of the beneficiary are not defined. In that case, the trust will be taxed at the trust level. The income will be taxed at the trust level. If it is a determinate trust where I have 3 beneficiaries and all 3 of them are 33% partner or beneficiaries of the trust, then it will be taxed at the beneficiary level.
Okay. Thank you so much, sir.
My pleasure.
Thanks, Tariq. We have a question from Nitin. Let me just unmute him.
Sure.
Tariq, you can hear?
Yes, sir. Good evening. How are you?
Good. Just some basics. So if there is husband-wife, they are called the settlers, right?
That's correct, sir.
So if the husband transfers the asset to the trust, then you open a new bank account, everything, right?
That's right.
Once you open a new bank account, the beneficiaries can be husband, wife, children?
Yes, sir. The bank account is for the trust.
Yeah.
So the beneficiaries are of the trust. They are not the beneficiaries or anything. So the bank account is now not in the individual name of husband, wife, or children. The bank account is in the name of the trust, operated by the trustees for the benefit of the beneficiaries.
Yeah. So suppose the husband-wife manage their stocks, debt, whatever, they can continue to manage it with the same ease in the
Absolutely,
trust
sir.
with the same beneficiaries when the husband-wife are alive, right?
Absolutely, sir. So it is as good as managing your affairs outside the trust. The trust has its own bank account. The trust has its own demat account, own trading account, and everything can be done through the trust. The only fundamental difference will be earlier you were signing and doing things in capacity of individual Mr. Nitin Rao. Now you'll be doing in capacity of a trustee of Nitin Rao Family Trust.
And when the shares are transferred, etc., long-term capital gains and all come in?
Zero. There are no long-term, short-term capital gain tax, nothing, because there is no consideration. It is a settlement into a trust without consideration. So your indexation values, everything will be from date of purchase.
So the original transaction remains as it is?
Absolutely, sir, because there is no consideration against the transfer.
Okay, and we are talking irrevocable. And if Amicorp
Revocable
was to
or
be,
irrevocable, it doesn't matter.
and if Amicorp is to be a trustee,
Right.
on that trustee committee, can one put a relative onto that trustee committee?
Absolutely. So you can have minimum, you require 2 trustees. You can have as many trustees as you like. In the trustees also, you can define roles and responsibility. So you can say that the decision making will happen through trustee number 1 and trustee number 2, which are family members. The administration of the trust will happen to trustee number 3, which is a corporate trustee.
And Amicorp will ensure the safety of the trust and all the...
Absolutely. The continuity part, the administration part, all of that can be done by the corporate trustee like Amicorp. And the decision making can be kept with the family member as a trustee.
Okay, got it. Thanks, sir.
With that, you could also do one more thing is you could have the trustee as a corporate trustee and the family member could become a protector of the trust and
Protector
overlook
of
all
the
the
trust.
activities. Yes.
So he'll be
And-
independent of the trustee company.
Absolutely. Because the trustee also carries responsibility and liability. A breach of trust is a non-bailable offense.
A breach of trust
tomorrow,
by whom? By Amicorp.
By the trustees.
And then the protector of the trust, what does he become?
So the protector, say for example, now taking the same example, that one family member can also be the trustee. Yes, he can be the trustee along with a corporate trustee. But suppose, say for example, if that family member is a cousin, and you don't want to pull him into liabilities.
Okay.
So then you can make that cousin or the family member a protector, who will overlook that the trustees are doing the right job. The trustees will seek guidance from the protector. So he's still controlling everything without carrying liability.
And that, I mean, I'm just asking stupid question. If the family is the son and the daughter, the son can be made the protector, even if he's a beneficiary?
Even if he's a beneficiary. If he's a beneficiary, he anyway has natural powers.
Okay.
But if you want to give him superpowers, you can even make him the protector.
Okay, got it. Thanks, sir. Nice.
Because, right, sir.
Thanks, Tariq. Tariq, if you can stop sharing your screen, I mean, in case the presentation, and we can have your view.
Sure.
Yeah, I am. There's a question which I'm going to read out to you. Do one need to specifically mention about the bank account balance in the will, or mentioning that all balance held in all the bank account under different names should be good enough?
You really don't need to get into the specifics of the bank balances. As long as you have managed to put in the right bank account numbers to the extent of which branch it belongs to, it can be covered in the will. Similarly for investments, because these are dynamic in nature. Your bank balances change every day. Your investments values change every week. So these are very dynamic in nature. What you need to mention is, if, for example, you have a private banking account with InCred, you can just say that my private banking account with InCred, customer ID number so and so, and all my investments under that, that can be covered in the will. You don't need to get into specifics of what the investments are. Say, for example, you have Demat account and you have 300 Reliance, 500 Tata. Those are again dynamic, keeps changing. So you just attach your Demat account number in the will by saying that Demat account number so and so will all proceeds in the Demat account will go to beneficiary number so and so. So that's all. You don't need to mention the bifurcation of the amount of values in those accounts.
Thanks, Tariq. Mr. Shyam Suri, you have a question?
Yeah, talking about the marital liabilities, let's say you want to protect from the marital liabilities like son's wife or daughter's husband. Again, you have to go by the irrevocable route, or is there any other way out?
So, revocable is always revocable at the settler's level. So if you are gifting assets to your son, when you are making a trust for him, and you are the settler and he's the beneficiary, it is already considered as irrevocable at his level.
Okay. Okay.
So if you are making the trust and you are benefiting out of it, then revocable, irrevocable matters. But if the settler and trustee are different, then it is anyway irrevocable at the level of the beneficiary.
Okay, got it. Okay.
Thanks.
So just to elaborate a little bit on this,
Yeah.
Say for example, now you gift one house to your son.
Okay.
and he's married, and tomorrow, God forbid, he gets into a marital dispute.
Okay.
The lady can claim 50% wealth of that gift that you've given him because it's now his.
Okay.
Whether it's a bank account, money,
Alright.
investment portfolio, real estate. But if it is in a trust, you cannot contest it because it belongs to the trust for his benefit. It does not belong to him. Something that does not belong to him, it cannot be challenged or asked for.
Whether it is revocable or irrevocable.
So if you have given it into the trust for the benefit of your son, it is at his level, it is irrevocable because he is anyway not the settler.
Okay, got it. Okay, okay.
So revocable, if you say that the trust is revocable, which means you can take it back.
Okay.
If you say the trust is irrevocable, you can't take it back.
Okay, okay.
But in both cases, the beneficiary can be your son.
Got it. Okay, actually, thanks for this clarification. It's very important. Yeah.
My pleasure, sir.
Thanks, Tariq. We have next question, which says, in your slides, you have mentioned that irrevocable trust is better for NRIs. Can you explain it a bit more?
So if I want to demarcate my Indian income versus my global income, say for example, if my beneficiaries are in the US and they're going to inherit, so it may vary depending on what I'm really trying to establish. If I want to demarcate my global wealth versus my Indian income, and I want to keep that wealth separate, then I should delink it from my name, and I can only delink it by moving it into an irrevocable structure.
Thanks, Tariq. We have next question from Mr. Prabhakar Sarvade. Sir, you can ask your question.
Actually, I got the answer. Somebody asked the similar question and I got the answer. So thank you. Thank you.
Thank you, sir. We have next question from Sheel Malhotra. Sheel, you can go ahead with your question.
Yeah, hi Tariq. Thanks for all the clarifications you have been giving us. My question is similar to one of the attendees here. If I have been making a lot of financial investments as an individual capacity, and later when I decide to form a family trust and decide to move all my financial assets, mutual funds, AIFs, etc., shares into the trust, now will I need to change the name from an individual to a family trust? Will that accrue capital gains or stamp duty, or I can manage it upfront?
You will have to change the name from individual to family trust, but that will not accrue any stamp duty, any tax implications, no long term, no short term, none of it will happen. Only when you are no stamp duty will be applied on movable assets. Only when it is real estate, that also an individual name, is when stamp duty will apply. For all other financial assets and all other assets, no stamp duty, no tax, no long term, no short term.
Okay. Thanks, Tariq.
Right, sir. Even real estate, if it is held through a company, you can just transfer the company shares into the trust without any stamp duty implications. So only and only stamp duty will be applied for real estate held in individual name.
And is there a different tax treatment if I have assets outside India? Could be real estate assets which I may want to transfer into the domestic trust?
So Indian trusts are again not the best tool to hold foreign assets. So if you have Indian trust, you should have an Indian company, and that underlying company should own your offshore assets, not the trust directly. But if you have foreign assets, then it is better to look at a foreign trust.
Okay. Thank you, Tariq.
Thanks, Tariq. We have next question from Mr. Ravinder Chawla. His question is, if an NRI who has assets in India passes away and he dies intestate, do the beneficiaries, let's say US citizen, NRIs basically, have to pay inheritance tax in US for the assets that they acquired in India post the succession certificate from the court?
The inheritance tax is always on the deceased and not on the beneficiaries. So depending on where the deceased is domiciled out of. So if a deceased is an NRI out of Dubai, for example, there is no inheritance tax in Dubai. So it doesn't matter where the beneficiaries who are receiving the wealth reside. It matters on who the donor is and who's the deceased. So if the deceased is a US person, then yes, inheritance tax will be applicable to the beneficiaries. If deceased is a UAE NRI, inheritance tax will not be applicable regardless of the beneficiaries being in US or UK. It is always on the donor and not on the receiver.
Thanks, Tariq. We have a question from Mr. Shyam Suri. Sir, I have unmuted you. You can go ahead and ask your question.
I have a HUF and then which also has some business interests. In US, HUF is considered a company or a partnership or a pass-through financial institution.
So they don't recognize HUF at all. So in most likely it will be a pass-through.
It will be a?
In most likely they don't recognize an HUF by entity by itself. In their books, there's nothing like an HUF that exists. So most likely it will be a pass-through.
It's a pass-through. Okay.
Most likely.
Most likely. Okay. Thank you.
Thanks, Tariq.
And then in the pass-through also, there could be two schools of thought. Pass-through at what level? Is it all considered as assets of the Karta? Is it all considered as assets of the co-partners? Because rightfully the legal owners of the HUF are the co-partners. So all the co-partners become rightful owners of the asset. So will US take it as all assets belong to the Karta or all assets belong to the HUF? Can be a debatable question.
Thanks, Tariq. I think we have answered almost all the questions which are there. And I would request if anybody has any question, they can pass it on through their relationship managers at InCred, and we will try and seek an answer from Tariq. And if in case you are interested in knowing in detail about how to form a will or a trust, we can arrange a meeting with Tariq and his team as per your convenience. Thanks a lot for sparing time to attend this session on estate planning. And Tariq, thanks a lot for the wonderful session. And it was quite insightful and informative. And we will share whatever questions we have for you to answer in the future.
Thank you so much, everyone, for being a part of this call today. And we'll be happy to take any questions that you may have in the long run.